debate between uploading on portal and communication continues. The limitation, in my view, triggers under section 107 when the order is communicated to the taxpayer. The dichotomy between communication and service as envisaged under section 169 through a portal, I don't see any controversy in this, but many high courts have passed judgments for or against it. Allahabad High Court started with Bambino International, where they held that uploading of an order on a portal is not sufficient. The SSC has to be communicated. Now, if we accept this theory of communication, then there is a question of who performs this on us. If SSC says, I got communicated 1 year after the order was put on portal, can revenue prove to the contrary? It is impossible because there were no orders sent by registered post. So whether uploading the order on portal or sending it through email is a valid service. No court says this is not a valid service. Court only distinguishes that uploading on portal and the communication are two different aspects of the same matter. What started with Bambino International against a show cause notice, so Supreme Court stayed the operation of show cause notice only on this ground to consider on merits whether the uploading on portal or communication are two different words and whether the date of communication, notwithstanding when the order was uploaded, will trigger limitation under section 107. Now, two latest judgments of Luxmi Traders by Allahabad High Court and Gujarat Marketing by Rajasthan High Court favor the judgment, and a lot of younger professionals are debating on this issue. I don't think there's a debate. At various high courts level, more or less, they are following the same rule that uploading on portal under section 169(2)(3) is not sufficient unless the SSC is communicated. Now, question is, no high court has considered how will SSC be communicated other than by the modes under section 169. There is nothing in VAT laws that you will send registered post and AD will come back. You prove registered post, prove AD. So once under IT Act a portal was created and all of us know, then is it really worth taking this issue? But we have to wait for Supreme Court ruling. I have examined this issue to the best of my capability. I hold a view 169 shall override 107 because if a provision gives a right of appeal, which is a self-contained code, so we might say communication is more important than service. But for the whole act, section 169 gives you 5 modes of service. If those modes of services are not accepted as a means of communication, then harmonious construction between the two provisions will make 169 a dead number. On whether it's beneficial to the SSC or not, we are not discussing this. Now, on this same issue, I would like to bring 2 more judgments into view, which we have debated, created videos. That is, first of all, first is on limitation, Kamal Infratech by Supreme Court. Again, a judgment of Punjab Haryana High Court, where an SSC went to High Court directly, and High Court said no, come by 107, and they also dismissed the writ petition on delay or laches. SLP filed by Supreme Court. Now remember, when you file SLP before Supreme Court, the law is unless SLP is converted into a civil appeal, Article 141 does not come into play, notwithstanding the observations made by Supreme Court in their SLP dismissal orders. But in Kamal Infratech, a DB of Supreme Court, Justice Bakshi and Honorable Justice Pancholi, made a very strong observation that SSC cannot overlook the service on portal, which is a valid communication. And they also made another observation while discussing SLP, that after limitation under section 107 is over, High Court jurisdiction under Article 2 to 6 is non-est. That is, if you have to file a writ, file within 4 months from date of communication, whichever date of communication you take. Otherwise, the writ goes. And again, when you see Bharti scrap, though this order was passed, one-page order, a speaking order, but here also when we go into detail, it was a dismissal by SLP at the threshold. SLP permission was given, but the Honorable Court did not convert this into a civil appeal and pass the order on merits. Therefore, both these judgments, Kabul Infratech and Bharti scrap, are not in a strict sense under Article 141, because these were not converted into civil appeals, but SLP were dismissed the threshold. So if we take the Kamal's Infratech judgment of Supreme Court given in July 2026 and the other judgments passed by in Luxmi Traders and Gujarat Marketing, I think there is a huge paradox facing us lawyers. Could these judgments have been passed when Bambino International is under stay? No doubt, if judgment under stay, only that judgment gets stayed. But if Supreme Court was seized with the larger issue, why should High Courts have passed the orders in detail, putting the revenue and the assesses in chaos? Tomorrow, if Supreme Court decides otherwise, then what happens to the appeals filed, admitted, accepted, pursuant to the judgments of Punjab Haryana High Court and Rajasthan High Court? Because the Supreme Court judgments are interpreted retrospectively unless they make their operation prospective. So if Bambino International is held against the SSE, that is, the Supreme Court accepts the observation made in Kabul Infratech that uploading on the portal is a valid means of communication under Section 169, then what happened to these judgments? And what happened to the various GST tribunals who admit the appeal based on these judgments? And there are thousands and thousands of such appeals. Therefore, friends, when we are studying Supreme Court judgments, we have to make sure that those judgments to bind all high courts and the revenue were passed under Section 141. Otherwise, the observations made in SLP, they have a very strong persuasive value, but they are not law declared under Article 141. Therefore, Bharti scrap as well as Kamal Infratech, both are very important judgments against the SSE, but they are still not under Article 141. I personally think Punjab Haryana High Court, Allahabad High Court, and Luxmi Traders, Gujarat Marketing, they should have deferred the matter and waited for the Supreme Court judgment in Bambino International. Because once you pass a judgment for these two states, these judgments are binding. Because in Bambino International, there is only an interim stay. And that Bambino International is against a show cause notice. Whereas Kamal Infratech judgment was against the final assessment order. So both also stand on a different footing. Show cause notice at the threshold, Supreme Court can take a view. But once you are against a final assessment order, a view has necessarily to be different. So I thought I'll make a video on this. We should tread with caution. File appeals, disclose this fact. The Bambino International is stayed by Supreme Court. But we are relying on the jurisdictional High Court judgments or other High Court judgments that have a huge persuasive value. So friends, service on portal and communication, there's a long road ahead for litigation before GST. And GST's special bench, I'm really shocked. What will they do in special bench hearing? They cannot pass any order or observation, nor they have any authority to even distinguish a High Court or Supreme Court judgment, which is jurisdictional. And what will the benches do after the GST order, if ever they pass an order? I don't think they will pass any judgment. They might hear and submit to the government for some kind of amnesty scheme if they have the power to do it, because GST is not their baby to get into policy making stuff. But can GST ignore Supreme Court, jurisdictional High Court judgments and pass? So if matter is pending under stay before High Court on such an important matter, then why will a revenue accept any other judgment? They will hold it. They say, no, judgment is pending, we shall wait. So there is a lot of chaos happening in GST mechanism, whether it's input tax credit, Bharti scrap, or Safecon appliances. So there are a lot of issues coming because Supreme Court is not converting those SLP into civil appeal and passing a judgment on merits to bind the authorities and all of us under Article 141. Therefore, whenever you watch a video given by any one of us, watch it carefully. These Supreme Court judgments are not under Article 141 because SLP were dismissed at threshold. Number two, most of the favorable High Court judgments, GST portal versus communication, especially by Allahabad, Punjab, Haryana, and now Rajasthan, even Chennai one judgment, are subject to judgment of Supreme Court in Bambino International. Thank you so much.